Hello and welcome to the Elements of Deep Sea Mining. I'm Eric Young. Today, July 7th, is the kickoff of the council meetings of the International Seabed Authority. To mark the occasion, I asked on Pradeep Singh, a legal expert in ocean governance. Pradeep has worked across the UN system on ocean climate issues, biodiversity negotiations, and the law of the sea, and he spent more than 7 months of his life in Jamaica attending ISA meetings. In this episode, we dig into the legal architecture behind seabed mining in areas beyond national jurisdiction, how the ISA was formed, what it's responsible for, and where its regulatory process stands today. We cover the backstory behind the 2-year rule, the current stalemate around benefit sharing, and what's likely to be on the table in this year's council session. This conversation is both an explainer and a roadmap for what's coming next, and if you want to understand the pressure points in this debate, it's a great place to start. Pradeep Singh, welcome to the Elements of Deep Sea Mining.
Thank you very much. Happy to be here.
So I feel like it's the mark of a lazy podcast host to ask the guests to introduce themselves. But if you can start way back, maybe tell us where you grew up and how did you come to be involved in the deep sea mining question.
Sure. I actually am from Malaysia. I'm from an island called Penang in the north part of West Malaysia. That's where I grew up. That's where I spent most of my life. And then later, after graduating from law school, started working in a law firm and then eventually with the judicial and legal services in Malaysia, working both in West Malaysia and East Malaysia in Borneo. And it was during my time in East Malaysia where I really got connected to nature, to the ocean, and to the environment, as well as to communicating with indigenous people and understanding different views of how to interact with nature, which then eventually led me to further my education, to pursue my master's abroad on the law of the sea, on environmental law, on climate law, and on indigenous rights and nature protection, which then set me off on a different career path in different countries, in the US, in the UK, in Germany, in New Zealand, and now in Portugal, where I recently joined earlier this year the Oceano Azul Foundation as a senior project manager for international advocacy and negotiations. And here I handle various ocean negotiations, including deep seabed mining and the International Seabed Authority, but also other topics like the Ocean Climate Nexus under the UNFCCC regime or the climate regime, biodiversity negotiations under the CBD or the Convention on Biological Diversity, but also this newly adopted BBNJ agreement for the conservation and sustainable use of marine resources in areas beyond national jurisdiction, just to name a few.
Cool. Before we move off of your bio, what is an LLM and why does a person need two of them?
That's a very good question. So an LLM is essentially a master's of law degree, and I did two. And of course, my, approach was or feeling was that one was perhaps insufficient, and I wanted something over a span of 2 years. And also it was for me a good excuse or reason to do two, to understand different legal systems and how they work. And so I did two LLMs, the first in the UK at the University of Edinburgh, and that was more specialized in international environmental law, in climate change law, and the law of the sea. And then I did a second one in the US at Harvard Law School, where I was able to focus more on understanding US administrative law, US environmental law, US constitutional law. And I believe this combination or this set of masters allows me or has allowed me to really understand the landscape when it comes to environmental law, the law of the sea, and how different legal systems approach it. And I think in my case, especially, it was a very rewarding experience. You don't necessarily need to, but I found it very, very useful and rewarding, and certainly applies very well to the career path that I have now find myself in.
Yeah, and very relevant for the current kind of situation with deep sea mining as kind of both an international law arena and now more and more becoming a United States domestic question.
Indeed. And so I think also the sort of educational background as well as experience that I've gained over the years that has allowed me to understand the situation a lot better.
And so, yeah, okay. So now you say you're working at the Oceano Azul Foundation, and you're involved in international law related to ocean governance, not just on deep sea mining. But are you going to be going to the ISA Council meetings this summer?
Yeah, indeed. So it has actually been quite a busy start to the summer. So we had the UN Ocean Conference, which was also another sort of forum that I particularly also contributed to and engaged in. And then there was also the Ocean Climate Dialogue that took place in the UNFCCC discussions in Bonn just a week ago. So it has been a busy summer, but it's going to get even busier, as you mentioned, because I will be attending the International Seabed Authority meetings in July, the 2 weeks of council and the 1 week of assembly. So it's going to be a long stay for me in Jamaica, 3 weeks this time. And interestingly, I was actually adding up the amount of weeks I've spent in Jamaica attending ISA meetings since 2018, 2019, and it's been more than 7 months of my life in Jamaica attending ISA meetings.
Wow. Okay, so you're well versed. Well, this is great because I want you to give the listener kind of an in-depth understanding of what's going on at the ISA and what we can and kind of should expect. And then especially maybe like what are the issues that they're going to be focusing on in this upcoming session. But quickly before we get there, just about the UN Ocean Summit that you were just at, I wonder if you can give your thoughts on that. I heard from a number of people the kind of narrative that it was a lot of talk, but there wasn't a lot that came out of it. But you're the first person I've talked to that's actually been there. So can you kind of give us an idea of what happened there and why it's important?
Well, I think the reaction has been mixed. Indeed, there was certainly quite a lot of talk, but I would say this has gone beyond the ordinary talk that we've been hearing for years. I think now the tone sounds more serious. I think states are indeed more vested in taking concrete action. And I do believe that we would see, starting from some difference in the approaches of states. And in the case of deep seabed mining, right, I think there were a lot of voices that express concern about seabed mining. I think some of these states that have talked about it are indeed planning to come to the International Seabed Authority to get more accustomed to the negotiations that are happening there. And I think, at least in the case of deep seabed mining, we will see some movement that the UN Ocean Conference brings to the ISA. Now, it's very important because if you remember the second UN Ocean Conference that took place in Lisbon, that happened in June of 2022. And it was, before that UN Ocean Conference, the number of countries calling for a pause or moratorium on seabed mining, that was zero. It started at that UN Ocean Conference in Lisbon. And then these countries then went to the International Seabed Authority and have been reiterating their position. And so now I think, at least in the case of deep seabed mining, the third UN Ocean Conference in Nice also showed that the momentum is there, that states are not ready for seabed mining to start now. And I think we can reasonably expect that they would carry that momentum to the ISA as well as to other fora like the UN General Assembly and so on, particularly with now this development in the US that we just briefly alluded to earlier, but I'm sure we will talk more about soon.
Yeah. So is it kind of the case that the role of the UN Ocean Conference isn't necessarily to get that much done, but it kind of surfaces the issues, it brings attention, it gets a bit of momentum going, and then it's these other kind of more practical in the details meetings that you hope kind of capitalizes on some of that?
That's exactly right. I think the whole UN Ocean Conference idea was more to generate or galvanize more conversation, political conversation on the ocean, with the view that then that ambition would be taken elsewhere and implemented through other means. So it was never meant to be a negotiating forum. Of course, they do negotiate a declaration at the end, but other than that, it's not a negotiating forum. It's more a forum for political conversations to happen. And it's very important in the case of the ocean, because in the case of the ocean, we don't really have a unified sort of negotiating forum like we do for climate, where we have the UNFCCC regime. biodiversity, where we have the Convention on Biological Diversity, where the Conference of the Parties meet regularly, in the case of UNFCCC every year, in the case of the Convention on Biological Diversity every 2 years, but Conference of Parties meet and they negotiate. We don't have something similar, broadly speaking, for the ocean. We do have the UN Convention on the Law of the Sea, and we have the meetings of the state parties to the Law of the Sea Convention, but that's more a formal forum where members are elected to the Tribunal for the Law of the Sea, for example, to the Commission on the Extension of the Continental Shelf, but it's not a forum to really negotiate things. We do have annual negotiations at the UN General Assembly, a resolution on the ocean and the law of the sea, but that's about it. And so the UN Ocean Conference sort of steps in, fills this gap, and allows, political discussions to happen with the view to increase ocean ambition elsewhere.
Yeah, that's interesting and helpful for those of us kind of on the outside thinking like, okay, another meeting with not much happening, or what's the point of going to conferences? And that is nice to kind of get a bit of an explanation of how things tie together.
If I may add, the one unique addition that this UN Ocean Conference had is that it was preceded by an Ocean Science Congress, a One Ocean Science Congress. Mm-hmm. And that was also very interesting and very unique because it allowed the scientific community, as well as knowledge holders, to come together to make presentations and so on. And this was all recorded, and there was a sort of report back that came from the Ocean Science Congress to UNOC, which was very positive. And so this was an encouraging step that, it's also showing that the importance for politicians and for decision makers to embrace science and scientific knowledge and other forms of knowledge in their decision making process. So that was another, I think, very unique but profound addition to this year's UNOC that I hope will continue into the next editions.
Yeah, very cool. Okay, so then let's go to the ISA and to UNCLOS. And you're the first guest I've had on that I think can give like a kind of a detailed explanation. I've had a few people kind of summarize what the ISA is and kind of what the role of UNCLOS is, but I'm hoping you can put more meat on the bones there. So give like the high level summary of UNCLOS and the ISA, and also what else UNCLOS does, because I think that a lot of people coming from the deep sea mining space kind of think, oh, UNCLOS is that document that started the ISA and is all about deep sea mining, but there's more to it.
Yeah, I'm glad you asked the question, but very happy to maybe take a few steps back to sort of explain how we got to the convention, how we got to where we are today.
Great.
And essentially, everything started to come together after the Second World War, where states felt, not just in the law of the sea, but in all areas of international law, it's very important to start codifying these rules of international law and to maintain international legal order into treaties, into binding agreements, so that we have it, in front of us in black and white. And so it was after that the efforts, at least in the law of the sea, intensified to codify what was previously customary practice into international law, as well as to resolve some other areas that were not really agreed yet, and then to sort of tackle also new issues that needed attention, which included seabed mining. And so in the series of years, we had an initial set of conventions, the Geneva Conventions, 4 conventions there, that was agreed and put into effect in 1958. And then we had another round of negotiations. But finally, it was in the 60s where actually deep seabed mining was one of the main issues that really pulled states together, saying that we need to negotiate another treaty, and we need to negotiate one package treaty and not separate agreements. We need to have it in all in one instrument. And deep seabed mining prompted that, because in the 60s, there was more conversation about these minerals. There was a publication in 1965 by John Merrill, sort of saying, oh, there's abundant resources on the seafloor. And that raised a lot of questions, especially for newly independent countries that gained independence post Second World War. This is the 1960s. More and more countries were becoming independent. And they were concerned about these mineral resources being exploited by those countries that had the means to do so, the so-called might is right kind of approach, first come, first serve. And so that was why in the late 1960s there was a lot of discussion at the UN General Assembly, prompted by this mineral resources, but also other areas in the law of the sea that needed more clarity, that actually led the UN General Assembly very overwhelmingly at that point in time to decide that we need to convene a conference to negotiate a new law of the sea treaty to cover all aspects of the law of the sea, specifically also on deep seabed mining. And very interestingly, in 1969, there was a resolution by the UN General Assembly adopting a moratorium on seabed mining exploitation until we have established an international legal regime for the benefit of humankind. And so I always refer back to this declaration from the UN General Assembly in 1969, already talking about a moratorium when we talk about a moratorium today. But we can come back to that later.
Huh.
Yes, it's very interesting. And I've written a paper about it that I'm happy to share. But that conversation or those series of UN General Assembly resolutions led to the convening of an intergovernmental conference. And this is how usually multilateral treaties are negotiated, that a conference proceedings is convened. And this took place from 1972, 1973 to 1982. That led to then the conclusion of the UN Convention on the Law of the Sea. And the UN Convention on the Law of the Sea talks about all aspects related to ocean governance and the law of the sea. It basically sets out what is the territorial sea, what is the exclusive economic zone, what is the high seas, what is the area, which is the international seabed area beyond national jurisdiction, as well as goes on to talk about environmental protection. There's a whole chapter on that. There's a chapter on marine scientific research, transfer of technology, and very importantly, there is also a chapter on dispute resolution, which means that if there's any disputes, that it is to be addressed through certain mechanisms, such as the International Tribunal for the Law of the Sea, which is the other entity that the Convention on the Law of the Sea created three entities: the International Tribunal for the Law of the Sea, more for the dispute resolution segment. It created the Convention on the Limits of the Continental Shelf to decide and to consider extensions of the continental shelf. And the third entity that was created was the International Seabed Authority, as an autonomous intergovernmental organization responsible for mineral resources on seabed areas beyond national jurisdiction.
Kind of interesting that there wasn't ever a kind of like an authority on biotic resources, that there wasn't like a international fishing authority set up, because I would have imagined that would have been one of the main issues.
It was one of the main issues. It was actually part of the discussion in terms of the exclusive economic zone, because that was one of the unsettled topics that the Law of the Sea Convention resolved in the end. Mm-hmm. But that was primarily related also to fisheries, and states basically wanted to ensure that they had as much space for economic control over fisheries activities, and that's how we ended up with the exclusive economic zone. And fisheries on the high seas was sort of designated as a high seas freedom. But again, there were some unresolved questions also for fisheries with respect to stocks that live on the high seas or that are migratory. And so actually, and I'll come to this shortly, but it's important to note that the convention, although it was adopted in 1982, and many countries signed the convention, over 100 within just the year of it being adopted, but the ratification process was slow. And the ratification process is what actually brings an agreement or treaty into force. And the convention said that once 60 countries have ratified the convention, then it would enter into force. Now, this was slow because a lot of industrialized countries were hesitant to become a state party to the convention. And the primary objection was actually on Part 11, which is the part of the convention that deals with the area and seabed mining. And so we actually needed another agreement, another round of negotiations between 1990 and 1994 to resolve some of these concerns that industrialized countries had, which included, decision-making, as well as, obligations to transfer technology to finance developing countries and so on, which these countries were reluctant to do. And so we had an agreement concluded in 1994 that actually modified certain parts of Part 11 of the convention. And once this agreement came into force, states were willing to or to ratify the agreement, which then very quickly led it to become a near universally accepted convention with the 1994 agreement modifications. To finally close the gap on the question that you asked, we also had another separate agreement in 95 called the Fish Stocks Agreement. And that agreement tried to close some gaps with respect to high seas fisheries and how migratory species between exclusive economic zones and high seas are sort of managed so as to ensure that, they don't undermine each other and they are complementary. And finally, I think there was indeed also another gap that was not addressed under the Law of the Sea Convention, which is the marine genetic resources on the high seas and how they are to be used. And that is why we have this newly adopted BBNJ agreement, which is so-called the third implementing agreement of the Convention on the Law of the Sea. So we had the 1994 one, we had the 1995 one, and now we have the 2023 one that sort of seeks to plug these gaps in the law of the sea in relation, at least in the BBNJ agreement, for high seas conservation and sustainable use of marine resources, genetic resources.
No, that's very interesting. And so famously, the U.S. didn't ratify the UNCLOS, but did that really matter up until recently, or did the U.S. always just kind of act in accordance with the parameters of the UNCLOS and all of these agreements that were signed? Was it just kind of like, well, we'll go along, we'll abide by the tribunal, we'll abide by the EZ zones and everything, but we just haven't actually signed off on the agreement because we want to leave ourselves an out?
Yeah. And I think, that has been the attitude of the US, sort of arguing that most parts of the convention are customary law. Of course, they do dispute some parts of it, or they have been ambiguous on their position on some other parts. And one particular part where they have been ambiguous is relating to part 11. But I think their position has always been that, they of course support the international seabed area being the common heritage of humankind. It's just that I think they may not fully agree on how the resources can be accessed and whether other countries can tell other countries that you cannot access these resources. And that has been their sort of reservation. But again, I think it really depends on who you speak to, and under different interpretations of international law. I think most scholars, most academics, and most states would take the position that when we talk about Part 11, that is already customary law, not because of the convention, but because of what I mentioned earlier, the UN General Assembly resolutions that we were talking about in the 1960s that preceded the convention, that already sort of designated this area as the common heritage of humankind, of which access can only be through an international regime that has been agreed. And we have that now with the International Seabed Authority. So most scholars would take that view that even though the US is a non-state party, it would still have to respect certain parts of the convention, and that includes integral parts like the International Seabed Authority being the only organization that has the mandate over these resources, and you would need to access these resources through the International Seabed Authority and the member states.
Okay, so then take us to the ISA and what its kind of role is. So I think that people who follow deep sea mining to kind of the limited extent, like I do, are aware that the ISA is trying to develop mining regulations, and it has some role in kind of determining the rules by which mining in the area can happen. But kind of, can you walk us through like what are the important aspects of their job? What are the main things that they need to get done that they are in charge of?
Sure. So as I mentioned, the International Seabed Authority, or ISA, was first established under the convention. So 1982 convention came into existence after 1994 when the convention came into force. And so that meant that the ISA came into existence. An important point to note here is that once you are a state party to the convention, you are automatically a member state to the ISA. So there's no other way to be a member state to the ISA except by being a contracting party to the convention. And then that happens automatically that you become a member state to the ISA. And as I mentioned, the ISA has the mandate to administer the mineral resources of the area. So they determine, what are the conditions, what are the terms and conditions to access these resources, and if such access is allowed, how any sort of revenue or benefit sharing is to be made. And here is very important to understand, I think, two things: that the primary consideration for the ISA is ensuring the effective protection of the marine environment from the harmful effects of mining activities. That is an explicit provision in the convention under Article 145. And many argue that until you can ensure the effective protection of the marine environment, you're not able, or you should not be giving out access to these resources, primarily for exploitation. And I think the second point to note is that the ISA has sort of moved in an evolutionary approach. So sort of like started out first by exploration activities, and that has been ongoing since the year about 2000. And we have now about 30 contracts, or 31 contracts that are currently enforced for exploration activities. But there are no exploitation activities as of yet, because as you said, these are currently being negotiated. So it's the ISA that comes together and negotiates and agrees and adopts regulations initially for exploration, and now that process is happening for exploitation. And I think finally, a very important provision in the convention that underpins everything is this for the benefit of humankind as a whole, which we find under Article 140 of the convention, saying that any exploration or activity or exploitation activities that happens on the international seabed area needs to be carried out for the benefit of humankind as a whole. And the ISA, through its member states, basically are given the trust, or are entrusted to act in the best interests of humankind as a whole. And so in approaching these negotiations, in deciding, what sort of terms and conditions to put in for access to resources for exploitation, what sort of safeguards to have in place, that's really up to the member states to come together and negotiate and agree on a set of regulations. And so that's happening at the moment at the ISA with respect to exploitation, where states are negotiating what conditions, what parameters, and so on, to allow access to these resources, as well as to ensure that it's actually in the best interest of humankind, and what sort of benefit sharing that we're going to derive from such activities. Because the last thing you want is that you adopt the regulations, you allow mining to start, and then you realize that there are no tangible benefits that are actually coming to humankind as a whole, and the resources, which are the common heritage, continue to get depleted.
So would you say that those are the three kind of sticking points in the negotiation, like the developing of the actual mining regulations and I've lost, but how to share maybe it's just those two. It's the details of the mining regulation, and maybe is it what kind of environmental impact assessments and tolerances have to be allowed, and then what do we mean by benefit sharing and how that goes, or are there much more sticking points? Can you kind of give us a walkthrough of like where the negotiations focus, where the points of disagreement are?
Well, there are quite a few, but it's indeed, as you said, sort of like putting it into a set of regulations, and that's pretty comprehensive. But it's not just about having it on paper, right? So inspection, compliance, enforcement, that is another area that is currently being debated, and states are still having varying approaches to how inspection, compliance, and enforcement should look like. But there is agreement that it's not just enough to have a set of regulations and then not enforce them, or not have the capacity to enforce or ensure compliance. So that's another very big set that's under negotiation at the moment. But
that's going to be kind of an additional role that the ISA will have to take on once mining starts. I think this is something that is underemphasized often, is like,
absolutely,
once mining happens, then the ISA is going to have to also do this enforcement. And
absolutely. And so it needs to be a fully functional regulator in that sense, and including to have capacity on inspection, compliance, and enforcement. Because if you don't have that capacity, then things would be open for abuse almost the very next day. And I think that's something that we can expect from the extractive industry from previous from previous experiences that we have in the extractive industries, that if you don't keep a close eye, then things would not go as planned on paper. But coming back to other things that need to be resolved, like when we talk about environmental requirements, there are things like monitoring and reporting, and that's something that's still under negotiations. Like, to what extent is monitoring required? How close should activities be monitored? What should be the parameters of monitoring? That's another very important topic that is currently being negotiated. But then there are other topics as well that are environmental related, but also financially related. The operational and technical capability of operators. So do they actually have the pockets to take on such activity? What happens if something goes wrong? And here we talk more about insurance. Who are the insurance companies that are willing to underwrite such activities, and are they credible insurers that can actually deliver if something goes wrong, which again underpins regulating an industry that you don't fully understand, where the science is still not clear, and where the extent of the impacts are still largely unknown, even though we have a good idea, but still largely unknown. And then also related to that is the externalities of mining activities. So we do know that the impacts from deep seabed mining could potentially be significant, and it could affect fisheries. In fact, more and more regional fisheries groups and the fishing industry are starting to voice their concerns about seabed mining and how that could affect fisheries. And so how are we going to account for these externalities? Not only fisheries and so on, but also other forms of natural capital. The function of the deep seabed or the deep ocean as a climate regulator, but also to sustain the marine food web and so on. Once we fully incorporate such externalities, would we really be left with any sort of tangible benefit or not? Which is something that at least private contractors are seeking to downplay or avoid, because they know that if we take or we fully integrate such externalities, then they would be a significantly loss-making industry if you were to fully account for such externalities.
Yeah. And I mean, as would so many other industries, really, if we could only manage to find a way to internalize externalities. Okay, and so that's very interesting. This is great, because this is kind of exactly what I wanted from you, is kind of some of these details that I think are often overlooked. But yeah, so just keep going. Like, what else does the ISA focus on, and especially how is benefit sharing talked about? Like, what are the proposals that can actually work in terms of that?
Now, that's a very important point, and I was about to come to that, because the convention also makes clear that there are other prerequisites or essential components that need to be discussed and agreed upon, benefit sharing being a very important one. And tied to that is the obligation for the ISA to actually develop a system of compensation for land-based mining developing countries, because it is anticipated that if seabed mining happens, that this could potentially cause economic difficulties to some countries, developing countries that are actually reliant on terrestrial mining activities. And so the ISA is obliged to develop this system of compensation for developing countries. And how the convention sees this would happen is that this system of compensation would be taken out from the revenues that come in from seabed mining activities. Here's the very interesting point. The council of the ISA has not started any discussion, formal debate on this system of compensation, and neither have they started the convention discussion on this benefit sharing mechanism. And so you have more and more countries, so countries that are not only those that are calling for a moratorium, but especially those that are calling for a pause or moratorium, saying that, we have the scientific concerns and we have the environmental concerns, and that's why we are saying we are not ready to move to exploitation, which is what those countries calling for a moratorium and others are saying, that we're not yet ready to allow exploitation to start. But it's also the economic and equity dimensions to it. We want to make sure that we don't adopt the regulations, allow mining to start, and then find that we don't agree on benefit sharing. That's A. Or B, that we don't have anything really for benefit sharing. If we end up with just a small amount of money, and I think there was some estimate a few years ago from the African group countries that it looks like we would just get something like 90 to 95,000 a year. And that doesn't make any sense, especially if we're going to have to carry all these other burdens that would come from seabed mining activities, including impacts on fisheries and other sort of, how seabed mining would affect the coast and climate regulation and whatnot. And so that's a very important discussion that more and more states are saying that we cannot adopt the regulations, we cannot allow mining to start until we also agree on things like benefit sharing and the system of compensation for terrestrial mining countries. Because if we don't agree that together, then we're just waiting for disagreements to happen tomorrow.
That's very interesting. I want to interject because I know my audience. I know that some people in their minds are saying, yeah, but these concerns about impacting fisheries or impacting climate are uncertain, or there's technology pathways around them. So I just want to set that aside. So anyone listening who's getting frustrated, thinking that Pradeep is saying these things are definitely concerns, just put that aside from your mind. And these are questions that need to be dealt with by the ISA. That needs to be determined whether or not they're concerns, and it needs to be kind of negotiated how to deal with those concerns.
For sure. And there are other topics that need to be negotiated and considered as well. For instance, the cultural connection and spiritual connection that some groups or some groups of people are saying, and some states as well now from the Pacific that are saying that these are also some things that we want to bring to the table that needs to be considered. How we consider this is something else, especially something so intangible, really. But it doesn't mean that, like with the case of externalities, it doesn't mean because it's hard to quantify it that you put it at zero. That number cannot be zero. And that's the conversation that we need to have. I don't think that anyone that is even proponents of deep seabed mining are not saying that it's completely harmless. I think everyone concedes that there is some level of harm. And so let's talk about that level of harm and let's try and understand it better.
And then before we move off of this, I just wonder, are you aware of any kind of existing examples of compensation or benefit sharing in kind of the international realm, or are they having to make this up from scratch? Because especially with this idea that a potential industry is going to cause harms to developing states that are reliant on natural resource mining, like that's something that happens all the time, has been happening. And it would be great if there was like compensation mechanisms, and there's other situations obviously of international externalities that would be great if there was sort of benefit sharing. So I just wonder, do they have some templates that they can work from for this, or is this like the ambitious first attempt at trying to do some of these things?
Not quite. So I think you do have in some national jurisdictions where they have established certain mechanisms for things like that, to include for externalities. In the case of at least benefit sharing, we do have the Nagoya Protocol for genetic resources under the CBD Convention. That has been negotiated. So there are some experiences there that are not necessarily transferable, lock, stock, and barrel, but we can draw on those experiences and those approaches to develop something that would be fit for purpose for the ISA. And finally, for the system of compensation to developing countries for land-based mining, there has been already a preliminary study commissioned by the ISA that was issued, I think, 5 years ago in the year 2020, where at least 13 countries have been identified that would be particularly affected from deep seabed mining activities. So the initial steps have already been taken. The initial steps have already been taken for environmental externalities. So some years ago, countries like Germany, Costa Rica, and others proposed to the Council, and the Council accepted this proposal and commissioned a study to begin the evaluation of natural capital. And we do already have the initial study from that saying that this is difficult to do. We need to develop a proper methodology for this, but we can already tell you that if you're going to incorporate the externalities, that cost is going to be high because we imagine the impact from deep seabed mining to be significant. And so that, the initial steps have already been done. It's just now about developing proper methodologies, which we can learn from other, experiences to bring in here and help the ISA develop something that is not just fit for purpose, but also agreeable to member states.
I really like that. I really like that the methodology has been started, and now it's a matter of getting into the details, because I think those details are where things get interesting. And there's lots of cases where things that we consider to be intangible or non-measurable kind of are measured and are routinely measured, and and we
Yes.
run our society off of kind of putting measurements on things that we would all kind of agree are inherently.
Exactly. It's not something new or something novel that's being suggested here. It's just, ensuring that because it's difficult, we don't say we can't do it and the number is zero.
Okay, I want to ask you what you anticipate to be kind of the active topics in this year's meeting. But before that, I've heard in a number of your previous kind of, I guess, some of your publications and some of your interviews, the idea that like at the time when UNCLOS and the ISA were being developed, we knew so much less about the environment of the deep ocean. And I just wonder if you think that there are any kind of standout aspects of these organizations or documents that you think would be different or ought to be different, or if they kind of do a relatively good job, even though they were developed at a time when the knowledge about this area was so different.
Yeah, and that's where one really very important, initially emerging, but I would say now established norm comes in, which is precaution, right? The precautionary approach or principle, which is now commonplace in international law. I think everyone agrees, or almost everyone would agree that, precautionary principle needs to be kept in mind when we're interpreting treaties, so as to ensure that, as we develop knowledge, we use that precautionary principle norm or maxim to inform how we take decisions. And so that's where it comes in right now, when we learn in the 1970s, midway when the convention was being negotiated, that was when hydrothermal vents was discovered for the first time, right?
Yeah, that's amazing.
And now we're learning so many new things about hydrothermal vents and about active and inactive hydrothermal vents, and how that's very important to sustain life on Earth and might even be the origin of life as well. And so this is the conversation that is happening right now. It's like bringing in the precautionary principle to ensuring whatever decisions that we take today ensures that we take it fully informed with developments in science, as well as bringing in something that already existed before modern science, which is traditional knowledge, into the decision-making structure, which was something that the convention failed to explicitly include, but interpreting it in consonance with contemporary norms and developments allows us to do this. So, whatever that comes in from science, whatever that comes in from traditional knowledge, we need to feed that into the decisions that we take. And indeed, in the last several years, we've seen more and more, new forms of discoveries or knowledge that are coming in and helping us to better understand things like how does life exist in the deep sea, when 50 years ago it was thought to be almost a desert, and now we're hearing very different things. Of course, that needs to be distinguished between the different mineral types that are being looked out for. So polymetallic nodules and abyssal plains, polymetallic sulfides and hydrothermal vents, cobalt crust and seamounts and all that. They all have different considerations. But I think it's safe to say that the assumptions that we had before this were all inaccurate, and we're now only starting to learn that or at least challenge those assumptions. And that is something that I think is really brilliant, because our jobs or jobs as researchers and scientists is to challenge assumptions and to bring about new discoveries. And so that's something that should be encouraged. In fact, I would say at this point in time, what the ISA should be doing is that it should also be at the same time focused on independent marine scientific research. And then that is disconnected from exploration activities carried out by contractors. Of course, through exploration activities, you also increase your scientific knowledge and understanding, but to have independent scientific research to challenge and to contradict those findings as well that are coming from exploration activities. I think that is something that the ISA could be investing more time and effort and resources in to really galvanize deep sea research and independent research to lead to informed decision making, because I think ultimately that's what we want at the ISA.
Yeah, that's a great. I mean, I imagine everybody is in favor of that, and then it comes down to this question of funding and where could the resources to fund independent research come from. I mean, I think that's one of the big recurring topics in deep sea mining generally, is kind of how much do we lean on the companies to take the risk and to take the financial burden of doing the scientific studies, versus how much do we kind of pony up from government or public coffers to make sure the science is done in a way that is kind of more generally targeted. Yeah.
Well, I think it's a combination of both. I think, contractors, if they feel they have a case for deep seabed mining, then they should also be paying towards independent research that can be channeled to the ISA for independent research. And I, in fact, think that we should place the burden on them to finance this as well. But the good news is also that more and more states are stepping up. And the EU, for instance, has dedicated a lot more funding for independent deep sea research. So there are more and more grants being awarded for independent deep sea research. So I think if there is a concentrated effort, if states come to the ISA and say, hey, why don't we do this? I think we would be able to see a substantial amount of money coming in from states, from philanthropies, and so on. And hopefully, at some point in time, the US would also see some benefit in independent marine scientific research and perhaps change course and invest more in that direction.
Yeah. Okay, great. Well, then I'm just noticing that the time flies by. So just, I guess, briefly, and maybe this will be a segue into what's going on with kind of parallel track of the applications to the United States. But what do you anticipate to be the main focus of this upcoming meeting of the ISA?
Well, at least in the council, we know that negotiations will resume, and I expect to see states insist on inserting more safeguards into the current draft of the regulation. So as we've seen in previous years, more and more states are getting involved in the process. I think, very interestingly, maybe we can talk a little bit about the 2-year rule here, because I think it's very relevant to what's happening today. So the 2-year rule is a provision that you wouldn't find in the convention. It's not there. It's in the 1994 agreement. It's one of the compromises that had to be inserted in because certain countries, industrialized countries, were not comfortable with the fact that, mining can be prevented just by objecting to the adoption of regulations. And this is a very important point because the convention says clearly that when it comes to the negotiation and the final adoption of regulations, including for exploration and exploitation, but we're talking about exploitation now, is that they need to be adopted by consensus at the council, which is this body of 36 states elected by the assembly, the plenary body, electing 36 states into the executive body that negotiates the regulations, and the regulations must be adopted by consensus at the council, which means that if there's just one objection, then the regulations won't be adopted. And as per the convention, then mining cannot start because there are no regulations. So in 1994, to correct or to address this perhaps uncomfortable situation that might come up in the future, where most states, except for one or two, are ready to go ahead with mining, and they're being held back by an objection or two. This provision can be invoked to then say that you have 2 years to complete the adoption of the regulations. Otherwise, applications can be submitted and can be approved even without the regulations being there. So it was intended for that situation that everyone wants to go except for one or two that's holding everyone behind. And that was one of the concerns of the industrialized states, that anyone for any reason can hold them back, including a small country or including for other, extraneous reasons, wanting to stop it from it. And that's why they put the 2-year rule. Now, it was invoked in 2021 in the midst of the COVID pandemic under very different circumstances. It was the opposite of what was intended, that states were not ready, or most states were not ready for activities to start, except for one or two. And it was invoked at a point in time, as I mentioned, in the pandemic, where the ISA was no longer able to meet. And that sort of put that so-called 2-year timeline for the ISA to complete the adoption of regulations. And if not, applications can be submitted. So again, it was not meant to be used in such a manner. It was meant for a situation that the negotiations are more or less complete, but they're being held back. And that's where it happened. And since that invocation in 2021, we've seen more and more countries come to the ISA to participate in the negotiations and to ensure that more and more safeguards are inserted before mining activities can commence. And this is important because it's through this development of rules, regulations, and procedures that the ISA member states actually dispense their obligations and responsibilities under the convention. They need to guarantee that all the requirements under the convention are met before the regulations are passed and activities can commence. And so they need to be sure that the effective protection of the marine environment can be guaranteed. They need to ensure that there's benefit sharing in place, and they need to ensure that there are sufficient liability safeguards and so on. And so here's where we find ourselves. I think more and more states are coming to the ISA and participating in the negotiations, and most of them are insisting on more safeguards. So that would be a very interesting round of negotiations because we're sort of halfway through the second reading, and we'll have to see where states stand and whether they're willing to make compromises or not. And finally, I hope we would at long last have this conversation on benefit sharing and other elements like that compensation mechanism that I spoke to you about, which are all very essential and needs to be considered as a package. And at the same time, of course, I think developments outside, and particularly in the US, that would also have a bearing on how the negotiations take place. But my sincere hope is that the ISA won't be distracted or moved by such developments, and they would, basically stick to what they are entrusted to do.
And what's the story with tell the end of the story about the invocation of the 2-year rule? So did the ISA make kind of a determination on that? What did they say? And is that even still in play, or did Nauru essentially withdraw that now that DMC is going in another direction?
Well, it's still in effect. And in fact, many would argue that the effect has already materialized. Let's put it that way, or crystallized. So yes, it was mid-2021 when that provision was invoked by Nauru on behalf of NORI, which is a subsidiary of the metals company. And that sort of put that 2-year timeline, which expired on the 9th of July in 2023. Mm-hmm. Now, what the council did upon the expiry of that timeline was to take 2 very strong decisions, actually, saying that commercial exploitation should not commence in the absence of regulations. That was taken by the council in July 2023. It sort of put in place a mechanism that if an application is now submitted at any point in time until the regulations are adopted, then the council will stop doing everything else and as a matter of priority, decide on how to deal with that application, including to close any legal interpretation gaps, which could include maybe even seeking an advisory opinion from the tribunal from the law of the sea to provide more clarity on this. And at the same time, in 2023, it was agreed that the ISA will come up with a new roadmap or a new aspirational indicative timeline, is what many states are calling it, to continue the negotiations with a view to adoption this year in 2025. Or if that's not possible, then to develop another roadmap as appropriate. And so that's where we find ourselves right now as a consequence of the 2-year rule. But I think a final point on the invocation of the 2-year rule is that actually may have backfired, I would say, or indeed factually has backfired. Because again, before the invocation of the 2-year rule, countries calling for a moratorium was 0. In fact, countries that attend the ISA and participate in the negotiation, that participation rate was low. There was only a few countries that were really engaged in the discussions and in the negotiations. What that has done is basically given the deep seabed the spotlight that it has deserved. More and more countries now showing up, whether be it media or national pressure or just their own priority that has sort of been rearranged to come into the fray and to say that this is something so important that we want to be heard and we want to take part in these negotiations, and that has led to what I would say is what is increasingly looking like a potentially more robust set of regulations that we would perhaps end up with, which might effectively also mean that mining cannot start until certain conditions are met, depending on how the negotiations go on from here on.
And I guess it's important for people who don't follow this too closely, the clarification that so Nauru triggered the 2-year rule by giving like an intention to apply, but they never actually applied. So even at the end of that 2-year rules, what you're saying is the ISA said, okay, well, we'll kind of deal with an application. We'll give it a priority if it appears. It's a little bit surprising that an application didn't then appear if their Nauru and Nori were trying to kind of push the regulations along, isn't it?
Yeah, indeed. And I think, some questions have been asked about whether this whole exercise has been in good faith or not. And I think that's something that member states would bear in mind when they are approaching this whole negotiations right now, because at least from my perspective, the only actor that I see wanting to start seabed mining anytime soon is this one company, the metals company. And it doesn't appear to me that there's anyone else that is eager to start mining anytime soon in the next few years even. I think there's been a lot of misleading discussions on China leading the race, or it's a force to be reckoned with. If we don't do it, they're going to do it, but there's no indication from them that they are going to start in the next 5 or even 10 years. So it's this one company that just wants to go ahead and is trying everything that it can do to try and force its way to start the extraction, whether in a legal way or in a way that contradicts international law, as many scholars see it. But I think the one point to note is that, even if we put the legalities aside, the one point is the legitimacy of such activities, which are not there, even socially or even under international relations. That's something that is really missing, and it's something that I think investors would be very cautious about, because it's not just about the legality of it, which is a problem, but the legitimacy of such activities, which is another very big problem, affecting also supply chains, but also insurance and whatnot.
Okay, well then, yeah, let's go there directly. So tell us your perspective on this regulatory avenue of the USA granting licenses in international waters. Maybe give the specific details. Is it your understanding that this application, which the metals company has made, I guess, under a US-based subsidiary now to the US government, is it actually an application to mine, and is it for the same areas as they had previously kind of been investigating under the ISA? And then, yeah, I'll just take us all the way to, like, what do you see as the international standing of the US going alone in granting mining in international waters? What are the risks that you're concerned about, and so on?
Well, to the first question, I think my understanding is that it's a combination of applications. I think they want to submit applications for exploration also to the US for the international seabed area, including areas that they have already obtained an exploration contract from the ISA. And in addition to that, there is a particular area where they are going to apply for exploration and imminent commercial recovery, which is basically extraction or exploitation, commercial exploitation. And so they've, I think, started the application process. I think they submitted an application and have been asked to submit a more detailed application for consideration, which should be happening as we speak. And then we'll see what the administration decides is the appropriate procedure to entertain such an application. So I think we need to wait for a bit more clarity on that process, whether or not that's going to involve things like, environmental impact assessments and stakeholder consultations and things like that. I think we're still waiting for more details on that. But the one thing I think to look out for is that it's easier said than done, because one, that there could be a lot of legal challenges domestically within the US that could happen. And secondly, the company that wants to mine, the metals company, they are reliant on partners, and those partners are based outside of the US, including or almost, exclusively in jurisdictions where the home country is a member state to the ISA. And so, irrespective of what the US thinks of the position under international law, those countries, being member states to the ISA, have a very clear position under international law, being member states to the ISA, that they cannot legally, under Articles 137 and 138 and 139 of the convention included, they cannot allow any of their nationals or companies under their jurisdiction to circumvent the ISA, because they've recognized that there can be no claims of sovereignty, sovereign rights, or even extraction of these resources outside of the ISA. So that's going to be, I think, a very interesting development to watch out for, that even if the US starts taking more steps in this direction. So they haven't authorized any application yet. But if they go down this road, that there would be a lot of legal challenges, but also practical challenges. And that would affect, of course, investors, but as I said, also insurance companies and so on, because they are not going to, or most of them will not put themselves on the line to suffer such financial risks and exposure, but also reputational ones, which I think is equally important. You had a second question there.
Well, I just what's the important context in terms of international law about the U.S. kind of going it alone, and what risks are you most concerned about with the U.S. kind of stepping outside of the ISA approach?
Well, my biggest concern is environmental. I think, but also, of course, the other safeguards that are there at the ISA. I think the ISA has spent a lot of time developing standards, developing thresholds, or at least starting to develop standards and thresholds to incorporate other forms of safeguards to ensure that, the ISA is a fit for purpose regulator. But particularly environmental, right? A lot of environmental requirements and monitoring requirements and so on. And so my biggest concern of the US authorizing such applications is that this would be a threat to the environment, because we just don't have the science in place to understand this, but we don't have the parameters and the safeguards that the ISA is currently negotiating based on the precautionary principle. And this would all be absent to it. So I think that's one thing. The other worry I have is this, area being the common heritage of humankind, which the US recognizes that it is the common heritage of humankind. It doesn't belong to the US, and it's a place where even the domestic legislation, DSHMRA, which is the act that applies for domestic mining in the US, also acknowledges that there needs to be some sort of benefit sharing regime. And so how are we going to proceed on that note when the ISA hasn't started negotiating it? And surely the US cannot, unilaterally decide what benefit sharing means to them, because that's something that all states need to agree upon. And so there are a lot of concerns there within the ISA, but also beyond, like if a state can indeed proceed in such a unilateral manner, what does it mean for other states, not just with respect to deep sea mining, but also other uses of the seas and so on. And we have other activities like navigation and shipping and submarine cables and so on, which are also security concerns. And we need to ensure that we have a great multilateral working system that works multilaterally and doesn't collapse as well. And so that's another area of concern that I think any sort of unilateral action could just cause, a state to be more brazen in other things or other aspects.
Yeah, no, I'm quite persuaded by people who point out that as the world becomes kind of more technologically involved, problems that really require international cooperation kind of rise more and more to the fore. And so things that threaten to degrade international norms and international cooperation, I think, ought to be taken seriously. I heard, I think it was Michael Every talked about how everyone uses geopolitics as kind of an explanation for everything. He said, people say that, but that's geopolitics as an explanation is like saying you go to the doctor and they say, well, I see your problem, it's biology. And so I just wonder if you can put a little bit of meat on the bones of the geopolitical situation and concerns around deep sea mining. Like, how do you see different countries positioning themselves in the deep sea mining space? And how does that influence the development of the international regulations?
So this is an area that I focus a lot on, and it's something that I'm still struggling with to fully understand, because I think it's a narrative that has been made with people not really understanding how it works, as you put it. So I think it's important to understand a few things. First of all, most of the discussion on geopolitics are not really focused on real estate. So like, having a license and so on. Of course, that is a projection of power and so on, China sponsoring 5 applications, but that is not really the geopolitical I guess, question that or concern that comes up. What is more the concern is the metals themselves, right? So being extracted from the seabed and the control of the market. And we know factually that the commodities market by and large is controlled by China, right? So the narrative is that seabed mining can help alleviate that market stress. And I think it's something to look into more detail, because for me, at the moment, the case has not been made that deep seabed mining can be done more economically than terrestrial mining at this stage. I think it would still be a lot more expensive for deep seabed mining to provide metals into the commodities market than existing sources. And I think that won't be displaced by deep seabed mining. In fact, I've made the converse argument, saying that deep seabed mining might even cause more problems because terrestrial mining operators are not going to back down. Most of them, having invested a lot already, they are going to double down and they're going to compete if they have to. That's assuming deep seabed mining will be competitive, but they're going to compete, and then we'll just see more of the same old problems on land, but new problems at sea if that were to happen. So I think that's the one thing to look at. That's the one point, whether, what's the relation with terrestrial mining. And I think the second very important point is that we're not really talking about metals that we cannot find when we talk about deep seabed mining. In fact, the extraction is going to focus more on nickel, copper, cobalt, and manganese, right? Those are the four key target metals. And you get those metals, you get those metals anywhere. You get those metals in Australia, in Indonesia, in Chile, in the Democratic Republic of Congo. So if indeed countries are concerned about supply chain strategies, then the better way to do it is to strike agreements with those countries, including in Central Asia, but those other countries that I've mentioned, to get those metals that you want. And then you have to consider about some of the rare earth elements that you would need, or other sort of elements like lithium, for instance, which you won't get from the deep seabed. And I think that's a big misconception, that a lot of people that I speak to seem to think that the deep sea has minerals that you cannot find on land. And that's simply not true. So just to emphasize that point again. So I think those are the two most important points to make when we talk about geopolitics. And maybe a third point would be that actually that, more and more research and innovation is sort of even displacing the need for such metals. Like, previously, and this was, in maybe even until 5 years ago, the one argument that deep sea mining proponents like to make is that we need seabed mining to get cobalt for electric vehicle batteries. But now we're seeing, just in 2 years or so, complete reversal of that, and more electric vehicle batteries are being made without cobalt. And so that sort of displaces also the need that deep seabed mining can play a role here. But in any case, I think maybe a final point on that is that it's important to ask this question: to what extent can seabed mining help or provide for to alleviate the commodities market? And if at all it's going to make some sort of a significant contribution, how much seabed mining are we talking about? Because if we are talking about one or two operations, then maybe the ocean can sustain that, depending for how long and for what distances. But if we're talking about 20 operations or something like that for it to contribute in a significant way, then we're talking about a total collapse, especially bearing in mind that some of these exploitation applications, particularly for nodules, those cover a really large area. When we talk about terrestrial mining, those are very targeted and concentrated in a very small area. I think if you add up all the terrestrial mining sites in the world, it's probably the size of a small country. But when we talk about one mining operation, particularly in the Clarion-Clipperton zone, for instance, that's a very, very large area that mining activities would take place. So anyway, that I guess would be my response to the question.
Okay, well, I notice we're coming to the end of the time that I had you booked for, and I feel like we've got a decent segue to my question about trade-offs. So how do you think about this question of trade-offs? How do we make decisions between balancing benefits and drawbacks between different value categories?
Well, I mean, I'll come back to something that I said in the one of the plenary sessions at the UN Ocean Conference, is that we need to be clear when we're talking about balancing and when we're talking about trade-offs, right? And I would say balancing is only possible once you've crossed a certain threshold. In the case of seabed mining, you first need to ensure that there is effective protection of the environment. Only once you can ensure that can you then start talking about balancing all other considerations. Because if you don't meet that initial threshold, then you're talking about trading off. That means you're losing in order to gain something. And then we need to seriously sit down and see how much we are losing and how much we are benefiting. Because as I said in the beginning, you don't want to end up with a situation that mining starts and you find out only a few actors benefit and then everyone else has to shoulder all the burdens that come from it and don't see anything tangible. But in terms of that, I would actually argue that, we now find ourselves in the planetary crisis. It's an ocean emergency. We know that the ocean is under unprecedented levels of threat now. Science tells us that very clearly. And so I think at this point in time, it would be irresponsible for us not to prioritize conservation. I think that needs to take priority over economic use. And we need to in line with the precautionary principle, I guess, we need to shift the burden of proof to the proponents to show that this is something that is safe, that can be done and that can meet the environmental requirements and standards. Because otherwise, we might just end up digging ourselves further down the hole. And here's where, I probably end with this message that we need to start putting a value on natural capital, and we need to understand that how sometimes just by conserving and protecting and doing nothing invasive is actually leading us to benefit so much. Like we're already benefiting so much from these ecological processes that are happening. And we need to understand that perhaps some short-term gain, a financial gain by extracting resources might just set us back and that we lose a lot more.
Well, that sounds like a good direction for future research, but let me ask you that kind of more specifically is what do you see as like the main outstanding questions that require research, that require empirical answers in terms of bringing the deep sea mining conversation forward?
I think we need to understand the financial models more, and we need to understand to what extent can we optimize benefit to humankind as opposed to private actors. I think we should shift away from thinking what industry wants as opposed to what society wants. And that's the sort of thinking that we need. We need more economists to come in to weigh into the situation. We have quite a lot of scientists, quite a lot of legal experts in this field, but only a few economists. And I would, really want to see that or see more studies coming from the economic and the financial side of things, so that we actually know whether seabed mining is an investment or if it's a scam. I think that's something that we currently lack more understanding of. From a scientific side of things, I'd like to understand better what sort of durations do we need, what sort of scale of monitoring do we need for us to understand the extent and the scope or spatial extent and temporal extent of seabed mining activities. And finally, I think the cumulative aspect of things. I think so far we've had scientific research focused on one small project that happens for a few hours or maybe 2 days. And then they conclude like, oh, it's not so bad. We see this, we see that. But imagine that same machine being 4 times bigger and then 20 of those machines operating side by side. I think that would be a problem. It just give you an example, like, if the apartment next door is having construction, I could bear with it, right? Maybe it's not so bad. But if all 6 apartments or all 8 apartments around me are having construction at that noise, that would be crazy.
Yeah.
If I'm being polite. And so I want to understand more of the cumulative impacts, because as far as I understand, a lot of these mining activities are going to be taking place quite close to each other. And so what that means for the region. And I think that is something that we need to focus on. Finally, also, maybe, I think a few operators have managed to show that they can extract these resources, but they've done it for a few hours or a few days, as I said. And I'd be very interested to see how that can be upscaled and whether that still makes economic sense, considering energy intensity and carbon emissions and so on, but also to transport those minerals to shore. And what about processing? We have very little clarity on actual processing sites and how that's going to look like. Usain Bolt can run 100 meters in 9.56 seconds or something like that, but that doesn't mean he can run 1,000 meters if you just times 10 at that speed, right? So it's going to all look very different. And so I want more attention, or I would like to see more attention on this, because I think that's very important for society, but also for investors and so on to bear in mind.
Well, those are all quite clear and kind of targeted suggestion. So I appreciate that. And yeah, thank you so much for giving me so much of your time today. Where can people follow you, and where do you suggest people look kind of elsewhere to get good information on the deep sea mining questions?
Yeah, I think that's a very good point, that we need to perhaps create some sort of repository for literature and so on. I'm sure there are a few out there. I think the Deep Ocean Stewardship Initiative, or DOSI, if you go to their website, under minerals, you'd get a lot of information more from the scientific side of things, from the legal side of things, or governance side of things. I personally have published a lot of papers that I'd be happy to share, but it should also be on my LinkedIn profile, and you'd be able to find more information there. Of course, the ISA website is also a useful source of information to find out more about what's happening there, including meeting dates and so on, what's on the agenda, and what are the documents that are being discussed. And I would encourage everyone also to go to the website and look at the ISA web TV for when the meetings start, because they will be live streaming those meetings, and I think it would be interesting for the audience to follow some of the proceedings that are happening there. Even if you can't be there in person, you'd be able to follow it at least virtually.
Great. Okay, well, I'll put links to all of that in the show notes here. And you say you're most active on LinkedIn, so if people want to keep up with what you're doing, that's the place to follow you.
Yeah. So Pradeep Arjan Singh, that's my name there, because there are a lot of Pradeep Singhs. But yeah, so look for Pradeep Arjan Singh. And then if you forget that, just remember the deep, because the deep is the deep sea mining connection as well. But I'm also a member of the delegation of the IUCN. So I've been advising IUCN, which is the International Union for Conservation of Nature. And so you could also follow the IUCN website and the briefing notes that they put up there, which the audience will also find very interesting, as there will be a lot of reports on the ISA meeting and preparatory papers that delegates and audience could follow. And I think finally, I forgot earlier as well, the Earth Negotiations Bulletin, ENB. They cover a lot of international negotiations, and they will also, they have in the past, and I'm very sure they will be coming again to the ISA to cover the proceedings there. So that would be a really good resource, because every day they will put something online to describe what happened in the day, and also all the pictures from there. So that would be a very good site to go to and to subscribe to their mailing list, Earth Negotiations Bulletin.
Great. Okay, I'll put links to all of that in the show notes. And thanks again for taking the time to explain all of this to the listener and to myself.
Thank you, Eric.